Mr. Chief Justice, and may it please the Court, petitioner's factual allegations do not show that the issuance of this subpoena objectively chilled petitioner's First Amendment rights. To some of the colloquies this morning about state law, New Jersey state law establishes that subpoenas do not require anyone to produce documents, and a party faces no penalties for non-production. Any legal duty to produce documents, and in this case, any disclosure of donor identities, is instead wholly contingent on a future state court order requiring production. This case is a perfect illustration. The state court has repeatedly declined to order production over 2 years of litigation. That helps explain why petitioner never alleged below that anyone actually has been or is objectively likely to be chilled by this subpoena. Instead, at most, the complaint alleges that the subpoena itself, quote, may cause donors to stop contributing. But that contingent language has never been enough for Article 3. The federal government's alternative credible threat of enforcement theory of standing is even worse. State and local governments issue tens of thousands of subpoenas every year. But the federal government's theory would risk turning many of these ordinary subpoena disputes into federal cases, even without a First Amendment claim. That would be a remarkable break from history and tradition. No court has accepted that theory, and this court should not be the first, particularly in a case where the question presented was itself limited to chill. Of course, plaintiffs who receive an administrative subpoena may have Article 3 standing in some circumstances, where, for example, the recipient faces some concrete harm or legal penalties from the moment of the subpoena's issuance, or where the recipient alleges that the subpoena is connected to other government statements or actions that themselves create objective chill. Petitioner hasn't alleged anything of the sort here. I welcome the Court's questions.